Ladies and gentlemen, welcome to Law on the Bosphorus Summer School. This year, as you know, our topic is the Istanbul Convention. Normally, Istanbul Convention, known as the Council of the Europe Convention on the Preventing and the Combating Violence Against the Women and the Domestic Violence. And in the first session of the summer school, we tried to present the Turkey's report. We prepared all together with Professor Sözüer, I and Hasan, Büşra, Hasan Kaya, Büşra, Özçelik, Meltem, Karanlık, Neslihan, and Mehmet, Utku. First of all, in the first part of my speech, I would like to talk about the historical process of the Turkey in terms of the Istanbul Convention. Turkey signed the convention on 11th May 2011 and without any reservation. And after the process of the necessary procedure of the entry into force of the International Convention, the Istanbul Convention entered into force on 1st August 2014 for Turkey. As I said before, Turkey signed this convention without any reservation. It's one of the most important part of the Turkish process without any reservation. But even though Turkey signed the convention without any reservation, the terms of the domestic violence as a political choice mistranslated. Accordingly to this mistranslated, the term of the domestic violence in the convention is considered as intrafamiliar violence in a restrictive way. It should be stated that such an incorrect translation limits the person to be considered as a victim. In this respect, protection of the family and the prevention of violence against women code, which is one of the most important achievements of Istanbul Convention, was chosen to protect the family, not domestic violence in its name. Although the concept of the domestic violence is defined in the Article 2 of the Law on the Protection of the Family and the Prevention of Violence Against Women, there is no any special protection in the Turkish Penal Code for the people who are live together in the same house besides the family members. So, unfortunately, in 2021, Turkey withdrew from the convention with a presidential decision on 19th March. And this decision was published in the official gazette 20th March, and due to the contract rules, which is regulated under the Article 80, subsection 2, the termination took place in 3 months period. So the Turkey, according to contract rules, the determination took place on 1st July 2021. Although Turkey withdrew from the convention, some gains were obtained during the period of the convention, which I talk about the protection of the family and the prevention of violence against women acts. The act of the domestic violence, of course, we have some rules in the criminal codes. For example, the Turkish Penal Code, which is enacted in 2005, includes various amendments regarding the discriminatory provisions found in the former code, and this sense contains a major step towards equality. So we can easily understand that the fundamental principle of the Turkish Penal Code about the human rights from the Article 3, which is said, neither discrimination can be made between the persons in the respect of races, language, religion, sex, nationality, color, sex, political tendencies, etc. So nor a person can be subjected to spatial and a different treatment before the law and the courts. And in the Turkish Penal Code, there are types of crimes that allows the domestic violence and the violence against the women to be punished. Of course, some of the crimes punish these acts directly, and there's a spatial crimes. But also there are some crime types where committing crimes with this motive is accepted as a reason that aggravates the punishment. These kind of the crimes, they don't punish directly to the behavior, not a spatial crime, but when they crime to the person, to women or the members of the family, the punishment will increase. So I would like also, sorry, in addition, in some crimes, if the crime is committed against the woman, to the crime which is investigated and prosecuted ex officio become depend on the complaint of victim. I would like to give some special examples. For example, there are some special types of the crime protecting family and the women. For example, abortion, sterilization, ill treatment, violation of the obligation arising from the family law, etc. And also there are some regulation which are increased the punishment when the victims are women or the members of the family. For example, normally intentional killing crime is not regulated just for the women or just for the members of the family, but to be committed against a spouse or divorced spouse with a motive of honor, processing by the family members, the punishment will increase. And also injury, torture, torment, child molestation, sexual harassment, or etc. Lastly, I would like to say that there are some provisions which affect the circumstances of the investigation. For instance, in Article 102, subsection 2 in the Turkish Penal Code said, if the sexual assault act is committed against the offender, suppose, conducting an investigation and the prosecution shall be subject to the complaint by victim. And the third part of my speech is about the cooperation of the law enforcement authorities and the judicial and the law enforcement authorities in investigating and prosecuting domestic violence and violence against women. Law enforcement play an important role in preventing violence and preventing the recurrence of violence. For this, it's necessary for the law enforcement to receive training on violence, to have a sufficient number of the expert teams trained in human rights of women and the equality of the women and men, and to have enough female personnel also. And one of the important roles in the ending violence in the authorities, how the victims of the violence are treated in these authorities and how they communicate with the victims are great importance in the women's struggle with violence, because judgmental and accusatory attitudes towards the victim increase their sense of loneliness and helplessness, and even cause the application to be abandoned. The most important restrictive feature of the Protection of the Family and the Prevention of the Violence Against Women Act is that the institutionalize the fight against violence in order to prevent violence and monitor the effective implementation of the injection decisions. It is envisaged, in order to prevent violence and monitor the effective implementation of the injection decision, it is envisaged to establish violence prevention and the monitoring centers, which is we called Schöning, which carry out their work on a 24 hours base and the 7 days also. These centers are charged with providing support services to people who are protected from violence. And in order to this act to be implemented, victims or third parties must report the complaint about the violence or danger of being exposed to violence to the law enforcement, public prosecutor office, the judge, the civil authority, provincial and the distinctive directorate of the Ministry of Family and the Social Policies, and also Schöning. From 2013 to 2017, Schöning provided services to 197,000 citizens, including 148,000 women, 38,000 children, and 11,000 men. Since October 2018, Schöning has been working in 76 provinces. Violence against the woman can manifest on the continuum It may occur in the form of different forms of violence throughout the relation. For example, economical, physical, psychological, sexual, harmful. And at the same time, violence can become normalized and often increasingly continue within this continuity. Therefore, early diagnosis and the intervention is necessary to prevent further violence and escalation of existing violence. For Article 51 of the Istanbul Convention emphasized the risk assessments and the risk management as a critical element in the preventing and combating violence against the woman and domestic violence. The domestic violence against the woman registration form with the scope of the law, protection of the family and the prevention of violence against women act is used by law enforcement officers for risk assessment and the recording case of violence against women. This form was updated and the new form started to be used in January 2021. In this form, it's questioned whether there has been previous act of violence between the parties. In case of going to crime scene, the observation of the law enforcement officers about the crime scene and the victims are included. Which type of the violence are exposed are determined according to types of the behavior that the victim of violence is exposed to. The sign that reveal phenomenon of the persistent pursuit can be mentioned. It is determined how often violence occurs and whether the victim needs medical and psychological support due to these acts. It is also determined whether an injection decision has been taken against the parties before. By including some risk increasing factors for the victim and perpetrators of violence, these factors are whether the person has a gun, whether he or she treats the victim or their relatives, whether the perpetrator has alcohol, drug, or gambling addiction, whether he has psychological disorder or anger problem, whether the parties are the stage of divorce or separation, whether there is an ongoing lawsuit between them, and also whether the children have been exposed to acts of violence or whether they have witnesses violence. Many questions that determine of the nature of the case, such as whether the victims or the children have any psychological or mental disabilities were obtained now. According to these collecting data, very high, medium, and low risk assessments can be made by the law enforcement regarding the case. And the key role of the law enforcement is an assessing and the managing risk requires the application of the victim focus. These approaches to be abstracted concepts and turn into specific procedure, actions, and attitude when working with victims. In addition to facilitating effective intervention to ensure protection in the certain situations, these approach enable victims to have a greater confidence and trust in the criminal justice system. While some of these procedures and the actions are detailed in this report, other actions and the attitudes should be addressed in pre or in-service training program and facilities, including training in the later stage of this project. I'm thankful for this speech, and I want to give the word to Hasan Kaya.
Thank you. I hope you can see me and also you can hear my voice. Before starting, I would like to say something. First of all, some of the topics we talk about overlapping to each other, but we try to touch upon the different aspects of the overlapping topics. And also, I would like to express my thanks to Büşra and Meltem, who put too much effort on this presentation and my speech. Now I would like to start with the first question of mine. How is domestic violence and violence against women defined in our legislation? Domestic violence and violence against women are defined in Article 2 of the Law No. 62/84, which I talk about later. Domestic violence, according to the definition in the legislation, Any physical, sexual, psychological, and economical violence between the victim of the violence and the perpetrator of the violence, and between the family members and the people who are considered as a family member, whether they live or do not live in the same house. On the other hand, violence against women is defined as the gender-based discrimination directed against a woman just because she is a woman or that affects the woman disproportionately, and any attitude and behavior violating the human rights of women and defined as a violence in this law. This was my first question. It was a quick one. The second one, which is quite long. What are the measures regarding domestic violence and violence against women? I need to talk about the law no 6284. First of all, I want to give a little historical background for this law. Under the coordination of Ministry of Family and Social Policies, meetings held with the representatives of non-governmental organizations, public prosecutors working on domestic violence, family court judges, and the head of the bar associations of 16 metropolitan municipalities, and the written opinions of all relevant public institutions and organizations and the non-governmental organization. Law of the protection of the family and the prevention of violence against women was prepared and entered into force after being published in the official gazette on 20 March 2012. Mainly the measures are in this law, so we can divide into two different measures type according to this law. One of them is protective measures and the other one preventive measures. The distinction is made according to whether the measures are mainly directed at the victim of violence or the perpetrator, and it makes it necessary to evaluate these measures separately from each other in terms of limiting individual rights and freedoms. If I have to start with protective measures, those are regulated in Articles 3 and 4 of the law. There are protective measures that can be given by administrative chief, the judge, and the law enforcement officer in cases where delay is inconvenient. These measures aim to protect the victim of violence. Then I will say I will tell you about step by step. First of all, the protective measures to be taken by the administrative chief. First one is providing suitable accommodation for the victim of violence, and if necessary, the children with him or her at her location or elsewhere. The second one, in case of a life-threatening situation, to be placed under temporary protection upon the request of the person concerned or ex officio. These measures can also be taken by the law enforcement officer in case where delay is considered inconvenient. In this case, the law enforcement officer submits this decision to the administrative chief for approval. The fact that such measures can also be decided by the administrative chief or law enforcement officer without need for a judge decision is very accurate in terms of preventing delays in implementation. Apart from those, other protective measures that administrative chief can take, for example, providing temporary financial assistance, providing psychological, professional, legal, and social guidance and counseling service, providing nursery facilities for the children of the protected person under certain conditions. When it comes to judge can decide change of workplace if the person is married, determining a separate residence from the common resident, also adding a family resident annotation to the land registry if the conditions specified in the law are met, or change of identity and other relevant information and documents in accordance with the provision of the witness protection law based on the informed consent of the person concerned, and in the event that there is a life-threatening danger for the protected person, and other measures will not be sufficient to prevent this danger. To conclude, in order to be able to take the protective measures, no evidence or document is required that shows the use of violence. Due to the nature of the protective measure, this regulation is extremely appropriate because these measures do not limit the rights and freedoms of the individuals or as much as preventive measures. When it comes to preventive measures, those are regulated in Article 5 of the law. Also, in case where the delay is inconvenient, law enforcement chief officers can decide, or the judge may decide to apply the following measures to the perpetrator of violence. Those are not to use words and behave that includes threats of violence, insult, humiliation towards the victim of violence, or immediate removal from the shared residence or its location and allocation of the joint residence to the protected person. Not approaching to the protected person, their residence, school, or workplace. If deemed necessary, the protected person does not approach their relatives or children, even if they have not been subjected to violence. But some of the preventive measures can only be decided by judge. Those are if there's a decision to establish a personal relationship with the children, the personal relationship should be accompanied, the personal relationship should be limited or completely removed. Not to damage the protected person belongings and household goods, not disturbing the protected person by means of communication or otherwise, delivering the weapons that are legally allowed to be possessed or transported to the law enforcement, even if he or she performs a public duty where it is mandatory to carry a gun, he or she delivers the embezzled gun to his institution due to his duty. In case of addiction, to provide examination and treatment, including hospitalization, not to use alcohol or drugs or stimulant substance in the places where protected person is present, or do not approach the protected person and their places while under the influence of these substances. And last one, applying to the health institution for examination or treatment and providing treatment. Those can only be decided by judge. Apart from those measures, it's authorized to decide on custody, trustee, alimony, and establishing personal relationship in accordance with the protective and supportive measures in the child protection law. In addition, if the perpetrator is also the person who provides or contributes to family livelihood, the judge may order interim alimony even if it's not requested by the victim. Those preventive measures decisions is made without delay. The making of this decision cannot be delayed in such a way as to endanger the realization of the purpose of this law. It's possible to decide on the measures within the scope of the law ex officio or upon request. Those who can make a request are stated as relevant persons, the ministry, law enforcement officer, and public prosecutors. Regarding the length of the measures, these measures can be given for maximum of 6 months for the first time. However, in cases where it is understood that violence or the dangers of violence will continue, it may be decided ex officio to change the duration or form of the measures, or to abolish or continue the same upon the request of the protected person or the ministry or law enforcement official. If the perpetrator of the violence against whom a measure has been issued acts in violation of the requirement of this decision, he or she is subjected to forced imprisonment from 3 days to 10 days by a judge decision. Depending on the nature of the measures violated and the severity of the violation, even if it constitutes an actual crime. In case of reviolation, this period can be extended from 15 days to 30 days, but the total period of imprisonment cannot exceed 6 months. Those are the measures can be taken according to 6284 law. Now I would like to move to my next question. The next question is, are there official or unofficial statistics in your country on domestic violence and the violence against women for the last 5 years? This is a very bothering question for my country, actually. And there are some reports on domestic violence and violence against women prepared by official institution, university, and women organization on different dates in Turkey. Detailed research titled Domestic Violence Against Women in Turkey was conducted by Hacettepe University and the Turkish Institute of Population Studies in 2008 and 2014. Also, the 2018 Gravio Turkey report explained in detail which criteria should be considered in the collection and publication of data on domestic violence and violence against women. Unfortunately, we cannot reach a detailed statistical data published by official institution. Reports and statistics are published by official institution, even if different figures have been explained very superficially for years. Finally, there are differences between femicide figures shared and the figures determined by non-governmental organization. It results in the fact that there is still not enough cooperation in the solution of this problem and that sufficient progress has not been made. It should be noted that it's not only possible to prevent violation against women by evaluating each event together with data, by getting the core of the problem only by sharing a healthy and detailed data flow with the society and researchers. At this point, although it's not possible to mention all of the superficial statistics, we would like to mention some of them in particular. As you can on the slide, these data reveal the dimension of the domestic violence. Preventing domestic violence and femicides imposes serious responsibility on all of us. Most of the femicides are committed within the family or in connection with the family. At the same time, most of the domestic violence is carried out in the woman's home. Although methodology of this report does not in detail, it does give a clear message for the overall picture. Women are exposed to the violence at their homes by family members. For the second figures, when we look at the figures in terms of killed women, according to the statistics published by the Ministry of Interior in 2012, while 336 women lost their lives, this figure was stated as 266 as of March 2021. The purpose of sharing the second table is to reveal that contradiction that I mentioned at the beginning. The figure that official institutions state as 336 was stated as 405 and 408 by different non-governmental organizations. As you can see, statistics have problems in terms of reliability. If we need to summarize, statistics have great importance, especially in terms of sociological and criminological aspects. However, both non-governmental organizations and official institutions are currently publishing very superficial and contradictory statistics. There is no doubt that the detailed statistical data are in official institution hands. Sharing them with the public will make a great contribution to the prevention of violence in question. In addition, it should not be forgotten that although these statistics are in terms of killed women, women who were subjected to violence but not killed remain in shadows as a black numbers. My last question is, are victims of domestic violence provided with measures in the fields of security, health, accommodation, and education in Turkey? And also, do non-governmental organizations contribute to these measures? Also, Mr. Batuhan mentioned mostly, I would like to mention as well, Violence Prevention and Monitoring Centers, shortly SHÖNİM, are units established in 2012 under the Ministry of Family and Social Policies to support women and children who are exposed to the violence. SHÖNİMs are centers where empowering and supportive consultancy, guidance and monitoring service are provided for the prevention of violence and the effective implementation of the protective and preventive measures that I mentioned early, where sufficient and necessary personnel are employed, preferably female personnel are employed in those institutions, and work is carried out on a 24-hour basis, 7 days a week because of its nature. Coordination services, psychosocial support, legal support, guidance, and referral to the relevant institution in terms of education and vocational acquisition, health support, service, economic support, receiving applications coming to the call lines and forward to the SHÖNİM. It is aimed to communicate with the relevant institution and organization in line with the needs and demands, and to carry out the studies to raise awareness in the society. In order to prevent violence against women, other methods have been developed in which women can get support apart from SHÖNİM. To mention these, for example, a woman using a smartphone can ask for help with an application downloaded to her phone. With the Women's Support Application, KADES, it is aimed to women who are victims of domestic violence or violence can access to 155 police emergency call center with a single click by opening the device and sharing the location information in emergency situation and the closest team or patrol to the scene where the call for help is made to intervene in the incident. Moreover, ALO 183 family, women, children, and disabled social consonant line continues to operate in our country. However, some details in the killings of women, which are reflected in the news, reveal that the measures that cannot be implemented as they should be, even though they exist legally, do not have the expected effect. Examples such as the request for measures rejected by the authorities, the killings of women that could not be prevented even though there is a decision of removal, and the return of the woman who applied to the police force for help to the home where she was subject to the violence, reveal not only the legal regulation but also the aspects of the social perception that should be criticized in terms of standing up to violence against women. Lastly, there are many important women's organizations in our country as well. Our women organizations open their doors to women who are victims of violence and provide financial, psychological, and legal support. Apart from this, it offers suggestions for the prevention of violence against women, carries out various projects and research, and carries out activities to raise awareness in the society. To conclude my part, it is extremely positive that both scope and the variety of the measures foreseen in the regulation and the fact that these measures can be implemented by the administrative chief, other than judges, or even by the law enforcement officer in case of delay. The procedure followed in applying the measures and the absence of evidence in some cases also speed up the process. Although the arrangement for the establishment of violence monitoring centers is an extremely advanced step, it should be emphasized that the importance of their number-wise dissemination is important. Apart from this, the effectiveness of the 6-month period foreseen in terms of preventive and protective measures is also worth discussing. It should be noted that laws alone are never enough to solve problems. Effective implementation of all regulations set out by the law is fundamental to prevent such cases. Thank you for listening and your patience. Now I would like to give the floor to my colleague, Neslihan. Thank you.
Hello, I hope everything is all right with my camera and the voice. So, dear honorable academics and fellow participants, first of all, I would like to thank the Professor Sözüer and my colleagues for giving me the chance for this presentation. Let me introduce myself first. I'm a PhD student in Istanbul University, Department of Public Law, and also I'm a teaching assistant in Recep Tayyip Erdoğan University. I would like to start with the first question by my side, whether violence against women is considered gender discrimination in Turkey. According to the very essence of this issue is that violence against women comes to the fore when a woman goes out of the socially determined femininity, and violence is used as means of discipline in order for women to re-enter that mode. With violence against women, it aims to control over women in society. Coming to the legislation in Turkey, Turkish criminal law reform in 2004 has been prepared in line with gender equality between women and men. For instance, the reform recognized women's right to autonomy over their bodies and sexuality. Also, sexual crimes are prescribed under the categorization of crimes against individuals rather than crimes against public morality. Also, the marital rape is criminalized and the mitigating circumstances in so-called honor crimes are abolished. When we take a look on the statistics of 2020 in Turkey, as my colleague made reference, why women are killed, nearly 1 of 3 are killed because they want to make decisions about their lives, such as asking for divorce or rejecting getting together, offer of ex-husband. So it's obvious that violence, which is a tool to protect and maintain masculinity, man's power, in one hand, evidence of dominant masculinity. On the other hand, it serves to eliminate the failure in achieving masculinity. Coming to the second issue, whether there are any special measures regarding children who are suffering from violence or witnesses to violence, the protective cautionary decisions which are prescribed in Code of Protection of Family and Prevention of Violence Against Women number 62/84 may be taken by the civilian authority about the victim and her children too, such as providing an appropriate shelter to the person and her children, daycare services, support the victim to integrate work life. Also, the family court can decide with regard to the perpetrators of violence if there is a previous decision to allow having a personal connection with their children, then the personal connection can be restricted or revoked completely. Among those, the judge may apply the protective and preventive measures as contained within the Child Protection Code, such as consultancy, education, healthcare, and accommodation. According to annual national action plans, special therapy and rehab programs will be implemented for children who have experienced or witnessed violence, or for children who are prone to violence or display violent behavior. Let's move to the third issue, the relationship between the investigating authorities and other institutions. In the first decade of millennium, plenty of protocols between police, Presidency of Religious Affairs, health professionals have been signed on preventing domestic violence in Turkey. With memorandums, it's reminded the police of starting proceedings immediately when a victim claims that she is suffering from violence. In the Code of Municipality, it's prescribed that the municipalities which have a population over 100,000 shall establish women guest houses. Also, to maintain specialization in investigative areas, domestic violence crimes investigation offices have started to be established in metropolitan areas within the body of prosecutor's office. As a pilot scheme nowadays, the perpetrators are subject to attending at the anger management, stress management courses, training and rehab programs which aim to change their violent attitude. Following Code of 6284 was promulgated, violence prevention and monitoring centers, abbreviatedly SHONIMs, are established in all cities in Turkey too. These centers are under the Ministry of Family and Social Policies, and the victims can reside in these centers with their children who are under 18. And here victims can receive support, counseling, assistance, and they can take vocational courses to make a living too. Also, the NGOs have guest houses for victims suffering from domestic violence. Coming to the last issue, the statistics during pandemic. This issue is actually kind of controversial since the statistics of Ministry of Interior and NGOs are completely opposite. According to We Gonna Stop Femicide platform, it's a civil action in Turkey movement, 60% of women are killed this year were killed in their homes. When we take into account these rates, it's concluded that femicides are a manifestation of domestic violence. According to the report of this platform, there has been a serious increase in the number of women who were found dead suspiciously during the pandemic process. But according to data of the Ministry of Interior, the 7th day before and after March 11th, which was the first coronavirus incident in Turkey detected, was taken into account, it was reported that there was a 31% decrease in number of domestic violence cases. Apart from these numbers, it was reflected in the media that convicts who were released with the amendment made in Turkish execution law due to the pandemic also resorted to femicide. Well, I guess this is a short one, but this brings me end of my presentation. Thank you for your attention. And now the floor is my colleague, Utku.
Thank you very much. I hope my video and voice are okay. First of all, hello to all participants. I want to present my sincere thanks to Professor Sözüer and my colleagues to giving me this presentation opportunity. Now, I have 3 more questions for response for the Turkey's country report. My first question is, do victims trust the judicial system? Even though there are not so many research or statistics about this topic, there are still a couple of official reports available. The one that I want to share is called Women Victims in the Judicial Process Research Report, which prepared by the Ministry of Justice, Department of the Victim Rights, and released in January 2017. The research was carried out in 3 different provinces in Turkey, and the data were obtained from the experiences of 30 women who were victims of violence with different education and economic levels. Although the research is a limited sample, its results are very indicative. The first finding of the report is that the rate of application to official institutions by victims of violence is very low. The numbers from 2014 shows that only 11% of the victims bring the incident to the judicial authorities. And even if they apply, they are facing lots of different difficulties, and this makes their situations even worse. According to the report, the first challenge the victims face is their lack of knowledge about the judicial process. Most of the time, they don't know what to do legally, they don't know where to apply, or how to act when they're exposed to violence. Second problem, when they apply to the judicial system, the process often proceeds unnecessarily very slowly. So this makes them feel very insecure about this situation. The third one is about security needs of victims. When they apply for protection from the violence, authorities sometimes do not take this demand seriously and behave carelessly. So because of that, they often face with violence again and again. Fourth and the last important challenge for the victims is behaviors of actors of judicial system, such as judges, prosecutors, or police officers. Due to negative attitudes of these people, the victims cannot easily express the details of the violence they have experienced, and sometimes they tend to hide them. So to summarize with all the information given, it would not be wrong to say that the trust of the victims of violence in the judicial system is at very low levels. Now, my second question is, what are the measures regarding domestic violence and violence against women? I'm going to try to answer this question from the criminal procedure law perspective. First of all, as you know, domestic violence and acts of violence against women are a kind of human rights violations. According to the established jurisprudence of the European Court of Human Rights, status obligations regarding human rights include their obligation to prevent such acts from taking place, as well as to carry out effective investigations into happened human rights violations. Also, as a matter of fact, according to Article 49 of the Istanbul Convention, states are obliged to ensure that domestic violence and violence against women are effectively investigated and prosecuted, and to protect the rights of the victims at all stages of these processes. So in order to carry out an effective investigation and prosecution regarding violence against women and domestic violence, the implementation of various measures in Turkish Criminal Procedure Code number 5271 may be applied. If it's deemed necessary in terms of concrete violence that has occurred, all the appropriate protection measures in the law can be applied in such events. However, the first and important measures that come to mind in terms of these incidents are arrest with warrant and judicial control measures. These measures can be applied if there are conditions required in the law for the suspect or accused who commits violence against women and domestic violence. The conditions sought in the law are the existence of suspicion showing that a crime has been committed and the existence of a reason for arrest. For example, if there's a strong suspicion of a crime based on a concrete evidence that the suspect committed of the crime of intentional injury against, for example, his wife, and there is a strong suspicion that he will commit the same act again if he released, it may be possible to apply the arrest or judicial control measure. Another important measure in terms of violence against women is the regulations on physical examination. Physical examination is regulated in Article 76 of Criminal Procedure Code. This regulation is especially important for women who are victims of sexual crimes. In some cases, it's very difficult to obtain evidence for these kind of crimes. So much so that in the concrete case, sometimes the physical examination to be carried out for the victim of sexual crime can be the only way to obtain evidence. According to the provision, although it is possible to carry out physical examination in cases where the victim's consent isn't available, for example, if victim doesn't want it, it can only be performed by doctors in line with the decisions of the competent authorities in a way that does not endanger the health of the person concerned and does not perform surgical intervention. At the same time, the examination will be carried out by female doctors if the woman victim's request and opportunity is allowed. The second part of this question is, what is the role of the prosecutor in implementing the measures? Actually, the primary authority to implement the protection measures in criminal procedure code is the criminal judgeship of peace during the investigation phase and the trial court during the prosecution phase. As a matter of fact, the arrest warrant and judicial control measures will be decided by the criminal judgeship of peace upon the request of the public prosecutor during the investigation phase, and by the trial court upon the request of the public prosecutor during the prosecution phase, or ex officio. In terms of physical examination, there is a similar situation like the above, but the only difference is that in cases of peril and delay, a decision can also be made by the public prosecutor. So in this case, approval from the judge or court is required within 24 hours. The third part of this question is, do victims have rights to request the implementation of measures? The regulation on victims' rights in criminal procedure code is included in Article 234. Among the rights included in the provision, the right to demand the implementation of protective measures is not included. So victims do not have the right to demand implementation of arrest with warrant or judicial control. Therefore, as a rule, although the victims do not have the right to demand the measures directly, it is possible to inform the authorities about the situation that indicates that protective measures should be applied in the case. In the terms of physical examination, victims have the right to demand a physical examination on themselves, such that according to the second paragraph of the Article 76, when the victims request a physical examination with their own consent, the decision-making procedure, the first paragraph, is not required. Now, this is my last question and also the last question of the Turkey's country report. What is the role of the victim's complaint in the investigation and prosecution of domestic violence and violence against women? In the investigation and prosecution process to be carried out in cases involving violence against women and domestic violence, the complaint of the victim will vary in terms of the crimes that will occur. For example, if the incident of the violence can be evaluated within the scope of crimes such as intentional attempt to kill, torture, or torment, the condition of complaint will not be sought. But in terms of acts of violence such as insults and such as sexual harassment, depend on the complaint. However, in this topic, there are two kinds of crimes I want to focus on. I think they are important. One of them is intentional injury. The other one is sexual assault. First, if the act of the violence constitutes the crime of intentional injury, a separate evaluation is required. Article 86, paragraph 2 of the Turkish Penal Code regulates the less punishable version of the crime of intentional injury, which has an effect that can be remedied by simple medical intervention. However, according to subparagraph A of paragraph 3 of the provision that we talk, if the victim is superior, descendant, spouse, divorced spouse, and sibling, the condition of complaint will not be sought. It should be noted that this is important. The expression of a divorced spouse in the paragraph was added with Article 7 of the Law number 7331, dated 8th of July 2021. So it's a new expression. Another important issue regarding this regulation is that in 2019, 3 different courts applied to Constitutional Court for the annulment of the regulation due to its unconstitutionality. As a result of the request, the Constitutional Court carried out an examination and rejected the request for annulment with decision number that you can see on the slide, and found the provision in conformity with the Constitution. According to Constitutional Court's review, I think this is important, injuries that can be remedied with simple medical interventions are among the most common examples of domestic violence and the violence against women. So the provision in question sets an example for the legislator's use of constitutional discretion in combating violence, and that the difference between spouses and siblings and other victims is based on an objective and reasonable reason. So the next crime I'm going to talk about is sexual assault, which is regulated in Article 102 of the Turkish Penal Code. According to the first paragraph, the initiation of an investigation and prosecution against a person who violates the physical integrity of a person with sexual behaviors is upon the complaint of the victim. In the second paragraph, the qualified case of sexual assault is regulated. According to the provision, condition of complaint is not necessary in case the act is committed by inserting an organ or other object into the body. However, if the act is committed against the spouse, the condition of investigation and prosecution is subject to a complaint. In other words, it will not be possible to carry out a criminal investigation and prosecution without the complaint of the victim who has been subjected to the act of qualified sexual assault by her husband. So that's all I got to say about the topics I have. Thanks for listening and thank you very much for your patience.
For the Teresa question, I can say something. Are gay people protected in the penal code in case of sexual assault? In our penal code, there is no differences between like men and women. So you can be a perpetrator or victim as a woman or a man. There is no differences. Like there is no certain things to this crime should be only committed by the man or just for the woman. So also violence between gay people also is protected by the law. For the second question, so this is your topic basically, child marriage. So maybe we can discuss, maybe you can discuss within the group because Turkish members also are in the group. So maybe we can say more of that. But also child marriage is completely it's forbidden under our criminal law. But yeah, that's it.
It is forbidden, but it is some way there is many child marriage. How can many people getting with children to marry it? This is the question. Hasan, Batuhan, and Büşra and Neslihan. It is forbidden, but if you look to statistic, many men getting with children, with girls to marriage. How can it happen?
Sorry, yeah, there are many reasons for that, Professor Adem. Because, yeah, the law is perfect. Also, I'm answering the Kainat questions also. The law is perfect, but implementation is a completely different thing because there are many actors within the whole process. Yeah, you are making the laws, but implementation is completely different because the police is in it, the prosecutor is in it, like the administrative chief is in it. For example, there are many stories that the child marriage is happening and the administrative chief was invited to that marriage and there is no problem with that. So we need to educate our people. We need to raise an awareness in the society that is wrong. Like there are many reasons for that. So we should try harder and harder to prevent such cases in our country. Also, the other countries probably has the same issue, but mostly in like tradition-based, in my opinion. But we can definitely prevent it if raise the awareness in the society regarding that. Thank you.
And by the way, I want to answer the first question. And the question was, what's your opinion about the criminalization of the stalking according to the compatibility with the Article 34 of the Istanbul Convention? In our Turkish Penal Code, it was regulated under 105. It's also a crime in Turkish law, which is sexual harassment if a person is subjected to sexual harassment by another person. The person performing such as is the sentence to term of imprisonment for 3 months to 2 years. So even he just go behind of the victim, it should be punished. So I think in that case, the convention, I agree with this punishment. So we should punish the people who has a sexual harassment, and so 34 Article 434 is regulated under the Turkish Penal Code also.
Professor Baytaz, am I allowed to add something on stalking part?
Yep.
Stalking actually is not, as the professor mentioned, is not a separated type of crime in under Turkish Criminal Code, but there is a crime type in Turkish Criminal Code 123, disturbance one's peace and harmony, but this punishment is like 1 year imprisonment, and there are alternative sanctions. So for stalking, people can ineffectively can only apply for the preventive and protection measures under the code of 6284, but this is not enough. It should be criminalized separately in Turkish Criminal Code, I think. Thank you, Professor.
Can I also answer the question of Kainat regarding the more strict punishment or trainings, if I get it correctly? For my opinion, it's like it's never solving anything. There are many studies, for example, for that penalty, like 50-50 people are divided, 50 of them saying that, yeah, it's definitely a good punishment for preventing the others want to commit the same crime, but the other one saying that no, it's not an effective punishment type for the preventing future crimes. From this perspective, also there is a principle of rule of law principle. Also, Turkey has trying to adopting that in any ways regarding the crime types or all punishment. So in my opinion, no, it's another good idea to getting more and more strict punishment. It never solves anything, because when we look at the Turkey case, we are always strengthening the punishment all the time, but the crimes are happening all over again. And it's not the effective solution. So we need to educate people. We need to raise awareness in the society, like with the whole non-governmental organization, official institution. We need to share the statistics, etc., etc. So there are many ways, but the strict punishment, it's not the correct one, in my opinion, of course. Also, I can answer the Dennis question regarding the Megan law. Sorry, just trying to understand the question. So this is a completely different topic, if I get it correctly. The aim of the punishment, has been discussing before too many years, to the ages 15th or 16th century. I don't remember the correct time. So the Megan laws are criticized many scholars within the US or Europe for many time, because even you have committed a crime, still you are a person and you need to have the right to fair trial. Also have a social life afterwards when you finishing with the sentence. You need to re-socialize, you need to be in the society as a person, because you punished your crime, you deserved, then you punished it, so you suffered from it, then you need to be a right to a person again in the society. So in my opinion, the Megan law is not a good idea, and also results in many different problems apart from the just
It's a kind of discrimination.
yeah,
also.
discrimination. Yeah.
So even I have I act some bad behaviors, but after that maybe it was the last time I have ever made it. But whole of my life, all the people knows me as a wife killer or wife. So it's not fair that Hasan also said it's a fair trial, and also this is the right of against self-incrimination. So in my mind, I'm also against the Megan rules.
Thank you.
And also, thank you.
There are many questions, so it's hard to follow.
Yeah, exactly.
Sorry.
What are the with another?
About Furkan question, how much we can trust the number announced by the government agency? Actually, we are not in places to answer this question, but for my personal opinion, of course, we cannot trust, because it's not a trust issue actually, it's a transparency issue, because we have different kind of data from like non-governmental organization and the official institution, but there is no like transparent flow of the data, so we cannot be sure. Like it raises lack of transparency, like yeah, so we cannot trust.
Exactly.
At bottom.
Nobody knows of the real numbers also, even the official. Nobody knows.
Also, the people always focusing on the killed ones. Like there are many women are exposed to the violence, and she is too scared to go to police, or she's too scared to call the police, like anything. So those are the dark numbers, and those are the important ones, because like in any way, when you go up and get contact with the like authorities, hopefully you will survive, or you will be prevented from getting be violated. Sorry. So the important part is the black numbers, in my opinion, again. And also withdrawal and annihilation of the Istanbul Convention. Also, it's not my place to to state reasons, because it's all political decision. So we are not in the place to know the exact reason for that. But of course, we are criticizing it because it's a human rights convention. It's a huge step down for Turkey.
But I want to add something, Hasan. Sorry for disturbing your speech. Even we withdraw from that convention, unfortunately, of course, but we still have some achievement from that convention. This act, which we call prevention violence against the woman and the family. These we have to. Okay, we couldn't save this convention, but we have to save the old achievement from this convention. So this is unfortunately we withdrew, but now we have to stand and we have to protect all the achievement from that convention from now on.
Thank you all lecturers. We are out of time, so we have to go to break. We will start at 12:30. Thank you, all of you.
And last thing, thank you for all these great questions, but we are run out of time. So you can ask those questions also in your like group coaches, because they're also like research assistant, they know the topic. So sorry about the we are not able to answer all those questions. Thank you again.
And lastly, I am really thankful for my colleagues who prepared that report for the Turkish report, and also the speakers. I'm so grateful. So thank you for you all for listening our speech. I hope you will enjoy all the program, and in the end of this program, we're gonna talk all together again. Thank you so much.